Again, thank you very much for joining with us today. We're here to talk about the implications of the recent decision by the NLRB regional director in Boston with respect to the union organizing of the Dartmouth College men's basketball team. And before delving into the specifics of the Dartmouth case, I think it's worth spending a few minutes talking about how we got to this point and what other litigation has been out there to address the question of whether the National Labor Relations Act, the statute that controls private sector employment relationships, applies to college student athletes. So we're going to spend some time looking at those legal developments, identify the concerns that our clients have already been bringing to our attention, and look ahead at some implications and some potential courses of action for colleges and universities to consider as we monitor the developments in this area. So briefly, in terms of history, I think most on this call will recall that back in 2015, we had a similar development there involving Northwestern University and their football team. Again, the regional director in that Northwestern case determined that the football players were employees subject to the National Labor Relations Act. That decision was appealed to the full board, the full National Labor Relations Board, and it chose not to address the question of whether or not student athletes are employees under the Act. Instead, the board, and this was a unanimous decision by the board, so it included both Republican board members and Democratic board members. They unanimously decided not to exercise jurisdiction over student athletes. There were some particular circumstances in the Northwestern case. The most notable was that Northwestern, as a participating institution in the Big Ten, faced most of its competition from public universities, University of Michigan, Indiana, Ohio State, et cetera, who would be outside the jurisdiction of the National Labor Relations Board, no question, because they were public entities and not private entities. But the board in 2015 put this issue to bed by deciding not to exercise jurisdiction essentially over the industry, if you want to think of it in that term. We were alerted to the issue 2-3 years ago when the new NLRB General Counsel, Jennifer Abrazo, issued a memorandum in which she said that her office was going to take another look at this topic generally, the question of whether collegiate student athletes should be treated as employees and entitled to the protection and coverage of the National Labor Relations Act. And in her role as general counsel, she serves to enforce and investigate compliance with the Act and to present issues to the Labor Board. And it was clear from that memorandum that she intended to do that and to have her regional offices be open to the concept of having college student athletes be treated as employees covered by the Act. And it's important here that we recall that there are two really distinct components to this coverage issue. The one we see in the Dartmouth case is the question of union representation. Are these individuals, these athletes, entitled to be represented by a union for purposes of collective bargaining over their terms and conditions with the institution? The other component here, which we want to make sure we have a line of sight on, is the provision of the National Labor Relations Act, Section 7, which is a section that creates rights for employees, creates a right to engage in concerted and protected activity for the mutual aid and benefit of other employees. And that's a concept that can arise even in the absence of a union on the scene or union organizing. And as we move forward, we need to be mindful of the implications here of this overall issue on both components of the law. And on that second component, the last piece of history before we get to the Dartmouth case, is that last year, the regional office of the board in California filed a complaint against the University of Southern California, alleging that its men's football team or football players, as well as the men's and women's basketball players, were employees under the act, and that the conduct of the university was interfering with their rights protected under the National Labor Relations Act, their so-called Section 7 rights. Two significant aspects to that case. First, not only did the board bring the action against the university, but they named the conference, the Pac-12, and the NCAA as respondents and have made the allegation that they are the three, the university, the conference, and the NCAA, are all joint employers of these individuals that the board would consider employees and that we ordinarily consider student athletes. And the second significant element of that case is that there's not a lot of meat to it. The principal allegation is that the university, and I use the term the university to include all of the respondents there, is interfering with the players' Section 7 rights because it characterizes them as student athletes. And that label misleads them into not recognizing their status as employees and their right to the protection under the law. And the second element of that case is that the board has identified certain policies that exist in the college student athlete handbook, particularly policies that speak to the players' social media activity, and again assert that these policies interfere with the students' rights under the statute. And the nature of the policies are, from the perspective of the athletic department, I would submit commonplace and again, from the perspective of the athletic department, reasonable, right? For example, in giving guidelines on social media use, the policy says, do not post anything that would embarrass USC, your team, or your family. You have the responsibility to portray yourself, USC, your team, your university, and yourselves in a positive manner at all times. Do not post inappropriate or offensive material, including information that is not public, such as tentative or future team schedules, student athlete injuries, eligibility status, and the like. Again, from the perspective of the athletic department, seems like perfectly reasonable and appropriate information to share with your student athletes. Those of you who have responsibility for true labor relations will recognize that these are the kinds of policies in the employer-employee context that the labor board has challenged as potentially interfering with employees' rights to share complaints publicly about their treatment as employees. So the USC case is not in a unionized organizing context. It is a challenge that is designed to raise these issues of whether a student athlete is an employee. And that case is currently pending in hearing before an administrative law judge. So we can anticipate that hearing will continue. Ultimately, there will be a decision by the administrative law judge, which gets appealed to the National Labor Relations Board, and depending on the results, potential appeal to federal court. So it will be some time before those issues get any clear resolution and we get any clear statement from the labor board and the courts as to whether in that context the law applies to student athletes. And that takes us up to the Dartmouth case. As I'm sure you're aware, earlier this month, the regional director, after a extensive hearing on the record, issued a decision finding that the men's basketball players at Dartmouth are employees under the Act, are entitled to union representation, and actually scheduling an election among the employees, which is currently scheduled, at least the last I checked yesterday, to be held next Tuesday, March 5th. Undoubtedly, there will be an appeal to the labor board here, but we need to focus on how did the regional director reach the decision that these student athletes are employees, and what does that mean for us, for your institutions? Let me just say very briefly that the regional director cut through the Northwestern case. You might be saying, well, wait a minute, isn't Northwestern precedent here? Isn't that the controlling board law? How does the regional director not acknowledge that the board has said we are not taking jurisdiction? And there isn't a lot of analysis in the decision. It's essentially this, that while the Big Ten is principally populated with public universities, the Ivy League, which is the conference that Dartmouth is in, obviously, is principally private institutions. And so I, the regional director, do not see Northwestern as a prohibition against pursuing this claim and this effort by the union to organize the employees, the players at the Dartmouth men's basketball team. And by the way, the union that's involved here is not a specific college athletics union. It is the Service Employees International Union, the SEIU, which has a fairly significant presence on many college and university campuses, representing true employees as well as representing students in a host of other circumstances, graduate students and work study students and the like. So how did the regional director get to the conclusion that the Dartmouth basketball players were employees? And we know one of the distinctions of the Ivy League is that these players are not scholarship players. And shouldn't that be a significant component of the analysis, differentiating the basketball players at Dartmouth as opposed to the football players at Northwestern? Turns out, no, that was not significant, at least in this initial decision. So we start with a definition of employee that has three components and is fairly low bar to establish employee status. The individual has to be performing services on behalf of the institution, being paid compensation, and there needs to be a measure of control or the right of control by the institution or the employer over the individual. If we think about the typical college athlete, we're sure to see a measure of control, right? The whole concept of what we do to, particularly in a team sport, to have a structured schedule of practices, training, meetings, and obviously the sporting events, the games, the travel, etc. Considerable control over the activities of the students by necessity. And so meeting the control test in the context of an athletic team, I think would not be surprising. On the issue of performing services for the institution, the focus that the regional director had was on the fact that these athletes proudly wear the name of Dartmouth on their jerseys, that it is a source of attraction for alumni, It is a source of revenue for the organization, and the director, the regional director, was quick to point out that the athletic department has its own communications, its own business office, its own marketing arm. So those are the factors that went into the decision or the conclusion that they are performing, the athletes, when they compete, are performing a service for the institution. They are generating revenue. They are providing support to alumni relations. They're providing entertainment to others on campus. And so in the regional director's mind, that constitutes performing services, performing work, right? Working for the university. And then there's the question of compensation. And again, drawing from some cases outside of college athletics, the regional director found enough benefits being provided to the college athletes, completely recognizing that these are not scholarship athletes, but the notion that when they are high school students, they get a first look and an opportunity to be considered at Dartmouth, which is not available to those who are not student athletes. They get training facilities and opportunities, access to athletic equipment that others do not get. Literally, the regional director said they get sneakers that have some value. They get free tickets to games that has value. And these items are sufficient under board law, according to the regional director, to constitute compensation. So we have performing services for compensation under the control of the university equals employment status. While I'm being quick in my summary, I think you'll see that those are thresholds that are not difficult to meet, assuming this standard remains, that it is endorsed by the National Labor Relations Board and by the courts. It's fairly easy to see its application at other colleges and universities and not necessarily Division I athletic programs, and not necessarily athletic programs. Similar arguments can be made with respect to the marching band or those involved in theatrical performances for the university. So it's not clear exactly where the limits are on this thinking. But for today, we're focused on how it impacts our athletic programs. Now, having said that, and the obvious risks that it poses, this is a regional director's decision. It's not binding. We anticipate that the university will pursue an appeal to the National Labor Relations Board, and it will have to address the Northwestern case and make a determination as to whether or not it now wants to take jurisdiction in this area, and if so, analyze the issues around employment status. And if the labor board reaches a conclusion similar to that of the regional director, the university would then have the opportunity through a rather complicated process of pursuing that issue to federal court for an appeal. So we're a long way from a final resolution on this, but you can see from the building blocks that we've been talking about here that the risks and concerns have got to be front and center. And I've given you my best perspective as a labor and employment lawyer for a couple of decades now, and I'm going to turn off my mic and let Rick talk about the perspective of this most recent development from that of a collegiate athletics council, as are many of you, to see what are the issues that are immediately at hand. And then we'll talk further about strategies and longer range implications. So Rick, the floor is yours.
Tom, thank you. Thank you very much. Appreciate it. And what a great summary. I really appreciate you putting in that work. Obviously, our group, our collegiate sports practice group, does not get involved with the employment aspects of collegiate sports. We're pretty much focused on the NCAA rules and regulations, et cetera. And I want to make a couple of quick comments about some of the things that you mentioned. The SEIU in the Dartmouth case is an entity that obviously is well known in the Northeast. But the entity that brought the complaint against USC is the National College Players Association, and that executive director is Ramogi Huma. And Ramogi has been involved in the Northwestern case, and he's also done other attempts to try and establish student athletes as employers or employees of institutions. So that was just one point I wanted to inform everyone of. This is a separate organization that is attempting the same outcome as the SEIU. In the USC case, a couple of the other elements that the court was considering relates also to the apparel contracts that the institution has, saying that the institution is using the student athletes for their own purposes and not allowing the student athletes to wear their own choice of apparel and get any kind of support for that from the apparel company. So it's another element in the case at USC that we're seeing is being used as a focal point for the court to determine that the student athletes are in fact employees. One of the other points that I wanted to bring up, I've had an opportunity to talk with colleagues and friends across the country who are not directly impacted yet by these decisions or the Dartmouth decision. But I do understand that the USC decision, as you mentioned, Tom, and as you referred to, is likely about 3 months behind in the timing of getting a decision, much like the Dartmouth case. So it won't be long before that decision is rendered. And I think that the individuals that are involved in the case are suggesting that it's very likely that the regional director is going to assert that and decide that these individuals are employees of the institution, and then they're going to have to go on appeal, like you said, Tom. So with all of that being said, I think that the questions that are arising on campuses are, what do we do? How do we do it? What is it that we need to be prepared for as athletic administrators? And quite frankly, as Tom alluded to, it's really going to be a long road before any final decisions are rendered. But I think that institutions are really preparing for the reality that if in fact student athletes are determined to be employees, they're going to have to make some decisions about how they run an athletics department and whether or not they can sustain all of the sports that they sponsor. As you all know, the NCAA has specific restrictions and requirements for establishing a division membership through the number of sports that are sponsored on a campus. And institutions, in large part, sponsor the equal number of student athletes in men's sports as they do in women's sports for Title IX purposes. It is likely, and I think this is the overwhelming feeling of many of the colleagues that I've spoken to, that cutting of the non-revenue sports is going to be the only way that they can continue with an athletics program that is going to generate revenue from the revenue producing sports. But that's going to mean a lot of changes within the structure of the institution. And it means cutting of jobs, lack of opportunities for students in different sports. And it's going to mean a wholesale change on campuses. We're already seeing the fact that there's NIL, the NIL decision from the Alston case has made major changes. We just had the preliminary injunction issued from a federal court in Tennessee last Friday that is beginning to impact the way the enforcement staff of the NCAA is looking at NIL cases. They're stopped at this point in time from pursuing issues related to NIL, and that's impacting the way that they operate their athletics program. But as it relates to the specifics of what Tom was mentioning, both the Dartmouth case and the USC case, there's another lawsuit that has been filed, which really is impactful to the Ivy League. It's a pending lawsuit in Connecticut, in the U.S. District Court in the District of Connecticut. And it's a claim that the league, the Ivy League, doesn't offer scholarships, and that's a violation of the Sherman Antitrust Act, saying that that's price fixing and the suppression of compensation to students that should be receiving some compensation for their participation in athletics. So it's another another opportunity for individuals out there to pursue litigation against both the NCAA and the conferences to try and figure out how and where student athletes sit in an employee-employer relationship, and whether or not that relationship is really just that, an employee-employer relationship. But I would say that in a summary, a brief summary here, that institutional administrators, people that are working on the athletic side of things, are simply being bombarded by legal decisions right now, and they're trying to figure out how best to serve their constituencies, the student athletes and the supporters of the university who do provide the revenue to support athletics. And it's a tough decision right now as to how they make their choices as to what they do with their programs. But I do think that for the most part, directors of athletics, senior women's administrators, presidents of institutions are all very concerned about the next step in order to follow the law and be a part of the solution rather than a part of the problem. In closing my comments, I want to harken back to when athletics was first organized back in 1906. Teddy Roosevelt was the president at the time, and he told the college presidents that, listen, you guys have a bunch of, you guys and women have a bunch of sports out there that are dangerous. And you need to regulate those sports so that people don't get hurt and aren't dying. So the NCAA was constituted for the purpose of organizing and keeping some type of centralized control over participation in an extracurricular activity. Interestingly, it wasn't until the 50s when television came along that athletics became more of a focal point for the boosters of institutions to give their hard-earned dollars to the institution so that they could have these sports programs. And with the advent of television, that really has been the driving force behind why student athletes are considered or are trying to be considered by these outside groups as employees of the institution. Don't know where it's going, but truly the principle behind college athletics has always been as an extracurricular. It just so happens that it's very popular with alumni, and the alumni are willing to put a lot of money towards the effort, and the institutions do realize great revenue from it. But if it's an employee-employer situation, then what I understand most of my colleagues and friends and peers on campuses are afraid of is that it's going to result in cuts to their programs, particularly their women's sports programs. Tom, I think I'm going to turn it back over to you, and if we want to get into questions, be happy to try to answer some.
Sure. Rick, before we do that, I want to mention a couple things, but thanks for that. That's really insightful perspective on how college and university administrators are looking at this situation. I want to identify three aspects of labor law that are now become implicated as we think more about whether our institution is at risk for having a challenge that our athletes are employees. And the first one is sort of fundamental. As you said, administrators, college leaders are wrestling with their position on this, their perspective on it. I would encourage them to formulate a position and make sure that their coaching staffs and those who are interacting with the students have an understanding of the situation, because this is a issue that is percolating among students, among student athletes, and we want to make sure that our coaches and administrators know what to say. And a large part of that is going to be based on the position that the institution takes generally. When you look at these issues, and as I said before, you really have two components of the statutory protection. One is this, I'll call it individual, although it's concerted protected activity outside of the context of union organizing. And where I think we are potentially most vulnerable is in the area of retaliation, right? Think of a classic case where an athlete is dissatisfied with some aspect of his or her athletic program, raises that dissatisfaction. Maybe it's a question of safety. Maybe it's a question of the burdens that travel put on the individual or on the team. And they raise a concern, and they are subsequently, have their playing time limited or some other consequence. Not because of the complaint, but because of their performance. But that disgruntled employee, that disgruntled player, files a claim with the National Labor Relations Board saying that he or she was retaliated against because they had raised this question of concerted protected activity. To me, that's an avenue where if the player is savvy to this legal development, that our institutions are at risk. And we need to make sure that, just like in the employment context, if we're making decisions that are adverse to a particular individual, we've got a legitimate, in the employment context, we say a legitimate business justification that's independent of any protected activity that they engaged in. So to here, a legitimate exercise of athletic discretion unrelated to their particular issues or complaints, because the potential is there for that litigation. That door is open. The other piece, the last point I wanted to make, is on the context of union organizing. And here I'm going to have to digress a little bit. Again, for those of you who know labor law, you know that within the last 6 months, the Labor Board has changed the rules on union organizing. The old rule was the union would garner support and file a petition with the Labor Board seeking an election. That's the path that the Dartmouth case was on. Within the last 6 months, the board has said, and this, again, the General Counsel has said, and the board has approved this approach, it's enough for the union to demand recognition, to say we represent a majority of the employees in this bargaining unit, okay, the majority of the men's basketball players, and we want you, institution, to recognize us as the collective bargaining representative. Under the current board law, that puts the institution on the clock. You have 14 days to file a petition with the Labor Board. If you don't act within those 14 days, there is a risk that the Labor Board will turn around and say, there was a legitimate request. We have enough information to establish that a majority of the quote unquote employees favored the union, information that you don't have, but the union would present to the board. And therefore, we are going to install the union as the bargaining representative, as a remedy for your failure to respond to their request for recognition. Now, this is a huge change in the law, and it hasn't been tested at all, but it scares me to death thinking of this coming up in the context of an athletic department that is not tuned into the possibility of union organizing of one of their sports teams, because that is a very short clock to react to. And so I encourage all of our institutions to be mindful of that and at least have a plan of action. If there is such a demand, we know who is going to handle it and how it's going to be handled. We'll deal with the specifics if and when it arises, but we've got to be alert to that potential, because 14 days is not a very long period of time.
Yeah. Tom, I think you make a great point there, and I completely agree that athletic administrators need to be guided by their general counsels on campus about how to deal with the very specific points that you brought up. And that has to be a conversation that begins to occur immediately in light of some of these decisions, and particularly if the USC decision comes out in the manner in which I think most anticipate. We have one question.
Go ahead. I was going to say, Rick, we have this question.
I'm going to probably pass it off to you, but I'd like to read it anyway from a colleague of ours. Assuming conferences and the NCAA stay reactionary to this issue, which is an extraordinarily interesting point to start out with, because you are absolutely right. It's unfortunate that the NCAA has been reactionary and not proactive about dealing with these things ahead of time. But the question is, if employment comes through the court decision, is it likely that student athletes will be deemed employees of the schools and the conferences or the NCAA? It seems to me that that great chaos that would ensue if the individual schools are employers. Tom, I'll pass it on to you to talk a little bit about that joint employer doctrine that you were mentioning in the USC case that I think is trying to hook in the NCAA and the conferences for purposes of being joint employers.
You're absolutely right that is a strategic decision that the general counsel has made, and the individual who raised the question is right to be concerned about the implications, right? In that USC case, there is a determination that the conference and the NCAA are joint employers. We know that the same NCAA practices apply across the nation. So in effect, the NCAA would be a joint employer with any institution that, or at least there would be the presumption that they are a joint employer. And here again, I'm going to digress into basic labor law principles, and I apologize for those who are not employment lawyers. We've seen a real aggression by certain government agencies, including the National Labor Relations Board, to expand this concept of joint employer status so that two or more entities are treated as jointly and severally liable for the how employees are treated, for any remedies and for collective bargaining obligation, right? By hooking in the conference and the NCAA, the labor board would bring to the bargaining table all three entities to deal with the negotiations over the particular team. And that's likely to lead to a standardized arrangement, if we think 6 steps down the line, which is what, logically, if you're trying to, if you think about the college athletics as an employment relationship, then one strategy is to develop that industry-wide collective bargaining agreement. Take the NFL or the Major League Baseball or NBA model, right? Which, by the way, has a non-statutory exemption from the antitrust laws. and superimpose that on college athletics. We had a former partner who was a Navy officer and actually a professor at the Naval Academy, who liked to use the word sea change. This is more than a sea change. This is would be a entirely different model. Throw out the current model and adopt a pro sport model. But that's the ultimate consequence of the position that the NLRB is pursuing here.
And Tom, I'll comment just briefly. The thought of having an antitrust exemption, I think, has been the NCAA's, the leadership, at least of the NCAA. That's their attempt, trying to work with Congress to try and figure out a way that the association and all of college athletics can obtain some kind of antitrust exemption. Interesting part about that is on the other side, people say, what business would ever ask the federal government to step in and run or control their business? Mm-hmm. So there's quite a conundrum there, and I think it's an interesting one. But I do think I think as most people know on this call, that's been the NCAA's attempt to try and work with Congress and the legislature to figure out how they can structure some federal legislation, so that the association can continue to work without any employee-employer relationship.
Rick, we have another question, which is, what could the workers' compensation implications be? Injuries, long-term concussions, and other similar issues, which is a great question. And really, it raises this thought, right? If the NLRB concludes that the student athletes are employees, it controls for purposes of the National Labor Relations Act. It would be a factor in the evaluation of employment status under other statutes, not necessarily controlling. And workers' comp is a great example. Workers' comp is a state program, so it's going to vary state to state. But what about wage and hour claims, right? We know in other circumstances there is other litigation over whether student athletes are entitled to the protection of the wage and hour laws. And to this point in time, to my knowledge, they've been found not to be employees, right? There's no obligation to pay them a minimum wage for the hours that they put in, or to pay them time and a half for the services they provide in more than 40 hours in a week. But a decision by the National Labor Relations Board that is upheld by the courts, again, we're assuming this down the road, does probably change the calculus on those claims, and you end up having the potential that workers' comp is the system that would cover their injuries, and in every state there's a protocol for immediate injuries as well as for long-term consequences of injuries. But it would again open up an entirely different rubric for handling those issues.
Tom, I want to briefly comment, because this brings back some memories for me. I had a teammate back when I was playing football in college who broke his middle finger. He was a receiver, and it wasn't so much of an impediment during the time he was playing, but when he finished playing, he had problems with his finger for years, and still does. And the question that he always posed to the school was, can you help me? Can you in some way, continue to treat me after he left the school? And I know there's thousands and thousands of issues like that. And it's really just the benevolence right now of an institution to say, yeah, come on back, we'll treat you, we'll help you. We'll try to do whatever we can for you if the injury was incurred while you were participating in athletics at our school. But I also know that there are hundreds that don't ever get that kind of consideration from institutions at this point in time. So, there's benefit again. There's both pro and con to the injuries that happen every day in athletics on campuses. Tom, I have a question for you. I'd like to just see if there's been any thought towards this. If in fact, at some point in time in the future, institutions are faced with an employee-employer relationship with their athletes, would that also be applicable, and could it be applicable to high schools?
Yes, it could be applicable to private high schools. Public schools are not covered by this statute, but certainly private schools. And, Rick, we were just ruminating on this and this notion of a new model that includes private equity in some of the collegiate sports, depending on how that gets framed up. Does that change what is now a public institution and a public institutions program into a private program? That's beyond my pay grade, but it certainly is an issue. If big time college athletics are going to be supported by private investment, does it render them subject to these same issues? Well, we're nearing the end of our time. I hope that this has been informative to folks. Please feel free to reach out to Rick or to me or to the bond attorney that you regularly work with if you have further questions. And we will do our best to keep you informed of developments in this area of the law. So thanks, everybody, and have a good day. Thank you, Rick. Good to see you.
Tom, good seeing you. Thanks very much. Really appreciate your insights.